wanted to welcome everybody. We've been getting a number of phone calls from our wonderful clients, and we thought we'd gather kind of the top 20 of the questions, concerns, issues that have been coming through our office, and also just some updates as well too. So want to welcome everybody at this time. Also to many of us that are on the call here have been with us for quite some time, so wanted to welcome you all for coming here today. We will be recording this, so if you do forget half the things that we're talking about, don't worry about it. Most of you on this call here allow us to protect you and ensure you. And so if you do have some questions after this, you need some specific one-on-one, I call it coffee and counseling together, please know that we can set some time up together so we can go over your specific situation as well too. So note that. These are the topics that are going to be covered. If you do have some questions, if we have time at the end, we will go over them. Most everybody is really has a lot of questions on the Family First Coronavirus Response Act. So we'll be kind of going over the specifics of that, the executive order, SBA loans, a layoff versus furlough, some EDD, some new developments there as well, California Warrant Act, the new reality. So are your people now telecommuting? And now that they're telecommuting, what are they doing? So putting those things in place properly. We've been getting a lot of calls in regards to insurance, my bills, eligibility, special open enrollment. So we'll be giving you some information on what's been passed down from the insurance commissioner and what we're seeing overall in the industry as well too. We're going to talk a little bit about Cal OSHA. For some of our clients, you guys are still open. So for those of you that are critical and essential infrastructure and you still have employees there, this is where you really need to double down when it comes to safety as well too. Workers' comp. If you're going to be doing a round of layoffs, could this be potentially an area where we see a number of CT claims go up as well? And we had some questions in regards to payroll on that. We all need to stay healthy. We all need to make sure we're communicating with our team. How are we doing that? And during this time, could we actually give some of our employees some tools that they need right here and now? We have a number of resources, maybe too many resources, but we have a number of resources for all of you. If we're presenting some things here, there will be some links in the back. And if you have any questions, please let us know. Understand that everything is changing by day. And so what was relevant yesterday may be old news today. So please keep that in mind. We're trying to give you the latest and greatest, but I think I'm reading upwards up to 200 pages of information a day now. So again, trying to be relevant, trying to give you the latest and greatest, but it is always evolving every single day. We have some frequently asked questions that I downloaded from Think HR. I think these are the ones that most people are pondering and thinking about. So I actually downloaded some of those frequently asked questions and put down the answers as well. So you do have copies of the handouts that are available here as well too. And at the very end, like I said, I know we tend to educate on all the doom and gloom and what to be careful of. But I do want to reiterate, we're kind of all in this together. I think that you are all seeing some employees that are going above and beyond, and others that are just skirting as well too, but also too as communities, I think we're coming together and becoming stronger. And so want to leave you all with maybe some individual challenges that I myself am doing right now too. So I wanted to introduce Mr. James M. Gilbert. James, also known as Jim, has worked with several of our clients. I've always heard of Jim. I always heard of how wonderful he was, how brilliant he was, how he handles depositions, settling cases and claims. And so I'm very, very, very pleased to have Jim here today to go over some of the new legislation also to chime in on some of the areas that I'll be talking about as well too. Not only is he amazing when it comes to the legal world here in California, he's also a master when it comes to legal world in Illinois as well too. So I'm very happy. Jim, thank you for being on the webinar today. I think we're going to get some valuable information from you today. And I want to introduce you to all of our clients as well too. So many of you are challenged right now with some tough decisions, furloughs, layoffs. What does that look like? You're putting together telecommuter policies. You need to all get those blessed. You need to make sure you're interacting properly with your sick, your PTO, and all these other different leaves. I highly suggest that either you use your own counsel that you have right now, but also too, I highly recommend Jim for those services as well. So we're going to be going over this presentation. Jim, wanted to welcome you. Thank you for being here today. All the folks that are here on this call are my babies, as I call them, my clients. My job is to ensure and protect them. And so hopefully this information here will help all of you in making some of these planning strategic decisions here in the upcoming weeks or even possibly today. So Jim, I'm going to give you the stage here. And okay.
Can you hear me okay?
Perfect. Sounds wonderful.
Great. Thanks, Toni. I'm more than happy to be here. As Toni mentioned, my experience is solely in employment law. I've been practicing employment law for over 20 years, primarily California, moved to Illinois more recently, but have maintained my client base in California. And as I'm sure most of you know, the California employment law changes basically daily. So I'm doing everything I can to always stay on top of that. To reiterate something Toni said, she indicated things are changing daily. I'd even go one step further and say things are changing hourly on this. We're getting emergency legislation passed that normally takes months or years to negotiate and then is approved to go into effect several months down the road so that we can prepare for it and fully analyze it. Now we're getting legislation that's being put together in 2 days. The most recent CARES Act that you probably heard about in the news that's being called the Economic Stimulus Package is 880 pages and was put together in a few days. So as you can imagine, states are issuing their own orders, counties are issuing their own orders. So what may have been solid advice 2 days ago or 4 days ago or even yesterday may not be solid today. So it's always advisable to double check your decisions when it comes to changing employees' pay or taking them off the work schedule or laying them off or terminating them, those things, especially now so more than ever. I can tell you that I'm sure I've dealt with a lot of the same questions you all probably have, because for my clients, I'd say going back to last Monday morning, that's basically all I've been doing nonstop since last Monday morning through late into the night every night, is putting out fires and answering questions and trying to just wrap our heads around this and what sort of obligations we have now. So I'm more than happy to speak with you all today, and you'll have to forgive my lack of a tie, but I'm working from home, as you can see, as I'm sure many people are, and in the home office today, it's business casual. So I'm more than happy to chime in when I can and answer any questions. And I've reviewed the presentation Toni's put together for you today, and she's got some great stuff in here. So I think everything today will be very useful for everybody.
So Jim, dive on into the Families First Corona Response Act.
Okay, so the Families First Coronavirus Response Act is basically provides for two things. First and foremost, this law only applies if you have less than 500 employees. So it only applies to small and medium-sized businesses, and which would include employers of less than 50 employees who've never been subject to the Family Medical Leave Act before. So if you're under 50 employees, the Family Medical Leave Act is going to be uncharted territory for you. But it's very limited in scope. It basically provides for two things. One is if the employee cannot work because they have to take care of a child, because a child under 18 is out of school because the school is closed, then they're eligible for up to 12 weeks of family medical leave. The first 2 weeks are unpaid, and then in which case they can use any available PTO or sick time. And then from that point on, weeks 3 through 12 would be paid. However, they're only paid at 2/3 of the employee's normal pay rate, and that's capped at a maximum of $200 a day. So it's capped at a maximum. If you have a full-time 5-day-a-week employee, it's capped at a maximum of $1,000 a week. The second part of it is the paid sick leave, which would provide 10 days of paid sick leave for all employees, for the employers under 500 employees. If it's a part-time employee, that's prorated. So for example, someone worked 20 hours a week normally, then they would get 40 hours of sick leave for the 2 weeks rather than 80 hours. So the thought is the first 2 weeks of the FLMA leave would be unpaid because the employees are also getting this additional 2 weeks of paid sick leave. So they would most likely use that for the first 2 weeks, or elect to use that for the first 2 weeks of the FLMA. So they would basically run simultaneously or concurrently. The paid sick leave, though, as you can see from the slide, has a number of circumstances beyond a school closure where the paid sick leave is triggered. So if somebody's ordered into quarantine, which is not a stay-at-home order, but where a county or government officials actually order the person to be quarantined, or if a doctor or healthcare provider has informed somebody that they need to self-quarantine because they've been exposed or because of symptoms or whatever it may be. The number 3 on there is if the person has symptoms of the coronavirus and they need to go seek a medical diagnosis, they need to go to the doctor, they need to get tested. Number 4 is if somebody needs to take care of someone who has been ordered into quarantine. And number 5 is the same one as the FLMA reason, which is they have to stay home to take care of a child under 18 whose school is closed. With the paid sick leave, it's the normal employee's pay rate up to a maximum of $511 per day, except that if it's for the reason of staying home because the child is out of school, that's just like the FLMA, that's capped at 2/3 normal pay rate up to a maximum of $200 per day. So this takes effect on April 1st. There's actually, the Department of Labor has put out a poster that can be downloaded from their website, which is a notice that if you're still doing any work and you still have your business open, that notice poster will need to go up as of April 1st. It does not apply retroactively, doesn't apply to anyone who's been out prior to April 1st. And in the case of a lot of employers, if your doors are closed, it doesn't apply at all because it's time off from work. It's not simply being paid because you're out of work. It's actually taking time off from work. So if you're closed or you've laid them off or furloughed them or temporarily taken them off the schedule, there's no paid leave to take because there's no work to be had for them. In that scenario, they're going to need to apply for unemployment. They won't be able to take the paid leave. In the event that somebody has requested the paid leave and then you decide you need to lay them off or reduce your staff, then I would say you probably need legal consultation to make sure that's being done correctly, because like most leave laws, there are retaliation provisions in there. So if someone's out on paid leave and you terminate them, you have to be really careful about doing that. And just a note, as far as if you're 500 or more employees, you still have the normal unpaid Family Medical Leave Act requirements, which many of these scenarios with various health conditions could trigger normal FLMA coverage for people who are exempt from this, or for anyone that's 50 or over as far as employees. And that type of leave is unpaid, but many of these situations could qualify as a serious health condition. So even if you're not bound by the paid leave, there may still be obligations regarding unpaid FLMA time, depending on the amount of employees you have.
Jim, we have a couple of questions here from the audience. One is the paid sick leave in addition to current sick time they get?
That's correct. The way it's written is the paid sick leave is not only is it additional time, but the employer cannot require them to use their existing PTO or sick leave. It's basically their option whether they want to use their existing paid PTO or sick leave, or whether they want to use this additional additionally provided for leave. And I would guess the reason for that is because of the caps on the pay. So an employee may get more under their normal PTO and may want to use that instead. But it definitely is additional and has separate rules and protections as opposed to the normal. Like in California, we have the automatic paid sick leave that everyone has to provide. It's separate and apart from that.
Perfect. Okay, another question. For those employees that health professional has told them to stay away, do we need a doctor's note?
That is a gray area. As far as whether they should to allow them to stay away or as far as clearing them to return.
I think it's probably, I guess, allowing them to come back. Is that right, Natalia? I'm trying to answer your question. They actually are still open because they're considered a critical infrastructure. So right. They are still open and running right now. So it would probably be allowing them to come back to work.
Right. So that scenario has come up a couple times with a few clients, and like I said, there's no sort of playbook on how to handle that one. What I've been telling people is, if the person's displaying symptoms in the workplace, if they keep coughing, they're having trouble breathing, they have flu-like symptoms, fever, etc., then they should be sent home. If they have someone in their household who has those sort of symptoms, we should not be bringing them into the workplace unless there's a determination that either those symptoms, the person's been tested or something like that and been cleared that they didn't have it or something like that. Even the people in the household of those individuals, we don't want to be bringing into the workplace. As far as, for instance, sending them home because of that reason, I don't think we necessarily need to get or require a doctor's note at that point. Right. The problem is going to be the availability of getting a doctor to see somebody. Certainly if they have symptoms, theoretically, they should be able to get tested and things like that. But the whole healthcare system's under such a strain right now, I would be hesitant to sort of force someone, hey, tomorrow, by the end of the day, you got to go see your doctor and get a note. I don't know that that's realistic. What I've been telling people is just err on the conservative side and tell them, they need to stay at home and they need to stay at home for 2 weeks if they're displaying symptoms, if they have a fever, cough, and those things, unless a doctor has cleared them to return sooner than that.
Got
it. If they've passed the 2 week point, then I would say it would be preferable to get a doctor's note to return, but all of the advice so far as self-quarantining has been 14 days. So I think, if they have trouble getting into the doctor, as long as it's been 14 days, you're probably okay to bring them back in. Obviously, it's more preferable to get a doctor's note.
Right. Okay. We have a question. If we are paying staff to stay home, does this still apply as of 4/1? So they're still employees. Yeah, they're still employees. They're just paying them up until, for the month of March. So they are still employees.
So I have several clients that are doing that same thing because of the timing of payroll periods. So basically, for employers who, let's say, for example, pay twice a month, their last actual payroll date, not the check date, but the last date of the next payroll period is March 31st. And we're already in the middle of that payroll period. So I have several clients who have just said, look, we'll pay everybody through the end of the payroll period. The paid sick leave will kick in on April 1st. It's just going to depend on what position you're in on April 1st. So example, if you say we're going to pay everyone through March 31st, but from that point forward, you're going to be off the payroll, you're going to need to file for unemployment because we're closed down, and you're just sort of carrying them on the payroll for, for the next pay period or through the end of the month, then as long as you tell them ahead of time that, after March 31st, you'll be off the payroll and you'll need to apply for unemployment. Once April 1st hits, there won't be there's no work. They're not going to be scheduled to work on April 1st going forward. So there's no work to take leave from. So if they're off work, no, the paid sick leave requirements won't apply. Now, if they do have PTO or they already have existing paid sick leave that's still on the books through the company, then my recommendation is I would offer them to, they can use that if they want. But as far as this specially added 10 days under the Families First Coronavirus Response Act, that only applies if somebody's actually working. So that's why I say it gets tricky in the scenario of if that kicks in, someone says they want to take the paid leave, and the next day or two later you decide, hey, I need to shut down because we're not getting enough business. Now you run into a little bit of a scenario where you might have trouble laying that person off because they've already enacted the paid sick leave. But they can't take it early, so that won't come up until April 1st.
Got it. Okay. We have a lot of questions here for you. Our next question is, can an employer tell an employee not to come back to work if he feels that the employee is not feeling well?
Again, that's now again we're in a gray area there. To me, the concern is well, there's several concerns. If somebody appears to be sick and it turns out they didn't have this, well, then everyone else is fine because they weren't exposed to somebody who had this. But if it turns out you're wrong, not only do we have to protect that person's health, but then we have our other employees who can get sick from that person. And so I'm advising people to err on the side of caution. If somebody coughs once in the workplace, should we pull them out? No. I mean, people cough and sneeze periodically throughout the day, But if somebody's repeatedly coughing or repeatedly sneezing, they have trouble breathing, they have a fever, they say they don't feel good. If it's anything that falls along the lines of the symptoms that are being displayed, then I think we need to be on the safe side and pull them out and not have them on premises. If it's possible for them to work from home, then that's advisable, and that's the best scenarios if they're able to work from home and we just send them home to do their work. If they have the type of position or job where it's just not possible to do the work from home, I think you're better off being conservative. I think you're certainly within your rights, particularly at-will employees, to take them off the schedule and say, look, you're going to have to go home unless you get clearance from a doctor. Now, if it's something that somebody has very temporarily, like they just say they have an upset stomach or something like that, it's pretty vague, and then the next morning they say they're feeling fine, no fever, nothing like that, then that's different. But the problem you run into is I've had a situation where with a couple people we've had to pull out of the workplace because they had potential symptoms, but they didn't tell anyone and they came in because they wanted to work and get paid. So I think you have to sort of err on the side of caution because you have to protect all the employees, including that particular employee. And providing a safe work environment is a prime consideration. And so I think if it comes down to it and somebody needs to stay home and it's unpaid time because they have no sick leave or PTO, just to make sure everyone else is safe and that they're not further endangering themselves, then I think that's the route you have to go. Now, if they go to a doctor and they get cleared, that's a different story. Again, the tricky area you run into is if you send them home now, let's say they have no sick leave and they're on unpaid leave, come April 1st, if they're still an employee on the payroll, then they can start taking that paid sick leave. So, just because if they don't have any sick leave or PTO now and you take them off the schedule, if it carries in April 1st, then now that other paid leave would kick in potentially. So.
Got it. Okay, we have furloughed employees. Do we need to email them the required DOL notice?
As far as
the notification, I guess?
No, I believe, and I will forward you so that you can send to your clients there's a fact that the Department of Labor put together, and I'll have to double check that, because I believe when I read it, it said if somebody is laid off or furloughed and they're not actually working, you don't need to provide them the notice. It's a the FAQ is very helpful in the sense of, like, what do we do if everybody's working from home? Like, what good does it do to press to put up a poster? You know, and it says basically, you know, you can email them, you know, fax them, etc. The poster or the document, it's just a PDF file. And I believe it says in the case of somebody who is laid off or furloughed or not actually working. Correct. Yeah, I'm just looking at the FAQ right now. Yeah, it says that it only applies to current employees. So if somebody's furloughed or laid off, then you don't need to send it to them. Now, keep in mind, if you can do it, you know, I would say err on the side of caution. If you have thousands of people you need to send it to, that might be, you know, a little more difficult. Assuming you have that many employees, you probably have a bulk email list. You can send things out to all employees. So I would say it's just a simple PDF, one-page PDF document. I'd probably err on the side of caution. Anybody you plan on bringing back, you know, I'd probably just go ahead and send it to them. You're not required to, but keep in mind also, things could change and you may bring it back a week or two from now, and now you've already given them the notice at that point, and you don't have to worry about that too. So
right, and a lot of our clients have are paperless as well too. Right. So if you do have that ability to put that on your server, have it on your payroll system, and maybe you do a push notification, that might be helpful as well too. Okay.
Absolutely, and the FAQ actually covers that situation. It also says if people are working remotely and things like that, you can, instead of posting it on the wall, if you have it like a company intranet or server, things like that, where you post policies and things, you can do it that way too. So okay. I'll send you the FAQ, and you can forward that to your clients, and it has the various scenarios of the different ways you can do the notice, as opposed to the traditional just, you know, put the poster on the wall type thing.
Got it. Okay. We have a question here. What about employees who have been on unpaid leave since before this crisis? Example, have been on FMLA since December or earlier.
So for those employees, presumably they won't qualify under any of the triggering conditions, because they won't be out due to a self-quarantine from a doctor because of coronavirus. They won't be out due to displaying symptoms of the coronavirus and seeking medical treatment, or due to a quarantine order. So for example, if somebody had a surgery or something like that and they've been off for a couple months, or some sort of medical procedure, they're just under normal FLMA rules. This sort of temporary exception, that wouldn't apply to them. Now, if they happen to also contract the virus, then they, you know, would qualify. But if it's for different reasons unrelated to the coronavirus that they were out and continue to be out, then they're just under the normal FLMA type rules and the normal leave rules. This is only applies just for these coronavirus situations, and that includes the schools. So for example, and I even have some friends in this scenario where they've you know, everyone's kids are out of school. So if somebody's been off for work and let's say their return date through the doctor was, let's say, May 1st, because they had some type of surgery and they've been out already. Well, even though their child is out of school now, that's not the reason they're out of work. They're out of work because they had the surgery and were ordered to be off. So it's not one of those things where you can sort of backdoor the schools being closed as a reason. You're really going to look at why are they not working. If you know, even if the schools were open and even if there was no coronavirus situation, they'd still be out in that scenario until May 1st, until the doctor cleared them anyway. So that's the reason they're out. So this emergency legislation wouldn't apply in that scenario.
Okay, we're gonna do one more question here, and then we'll continue on and maybe ask some more at the very end too. So we have a question here for calculation of pay under the Emergency Paid Sick Leave Act. Do we include OT for pay, or do we just use base pay times the hours normally worked for calculation of pay under paid sick?
Yeah, so that's a good question. This is federal legislation. In California, it's always been a complicated issue as far as overtime laws and leave laws that provide things like regular rate of pay or regular rate of compensation, because those things get defined differently under the labor code and under other types of laws. And so I would say for that, I don't really have sort of a one size fits all type answer. That's something I'd have to specifically research and look at, because the current act that they just are voting on right now is 880 pages. This FFCRA Act that we're talking about was several hundred pages. I'd have to really dig into that and on all the definitions to see if they put in a specific rate of pay, because keep in mind, this is a federal law. So if they don't have a specific definition, then now we're looking at how does the Federal Fair Labor Standards Act define it, not how California defines it, because this is specific federal pay or federal leave. So that's something I'd have to look at that specific, research that specific issue. But it's a good question, for sure. It's something that needs to be determined before you pay out those type benefits.
Perfect. And then one last question, and we'll take the rest of them at the end. Do they have to request this leave, or can we automatically pay them these sick hours for the time that they are missing?
Well, I would say, I'm guessing in that question, are we talking about somebody who they have to be out of work, so we're basically just going to give them the paid sick leave since they're not working, as opposed to them actually being sick or qualifying? Because keep in mind, one of the things we have not talked about on this particular act is this paid sick leave and this paid FMLA time, there is a payroll tax credit for the amounts paid out. So that basically you're advancing that money, but theoretically on your future payroll taxes, you would get a credit for what you paid out. And there has to be a certification to the taxing entities that this was appropriate and qualified leave that you paid out and that you actually paid it out, and there's paperwork that has to be filled out. So I would not advise giving someone just saying it's going to be paid sick leave, so because they're out anyway, and that way they get paid and then we'll get the tax credit back. If it's not a triggering event that qualifies, certainly as an attorney, I would not advise going down that road if they don't actually qualify. Now, if it's a case where they're actually sick or displaying the symptoms or something like that, and then we're saying, do we need them to actually say something about ask for it, or do we automatically pay it? I would say if it's something where they qualify, then I would pay it, because you're going to get the payroll tax credit back anyway. So I would bring it up with them, because you'll get a payroll tax credit down the road back for those funds. So I would certainly say if they look like they qualify under one of those scenarios, but they're just not really aware of it, or they haven't looked at the poster, they haven't asked you, I wouldn't hesitate to say, hey, look, you should probably go on this, federal paid sick leave, and that way you can get paid while you're out, keep the employee happy, and then you get the payroll tax credit down the road for what you ended up paying out for that leave. So.
Got it. Okay. And so one of the, I guess, reasons for the sick leave is it's subject to federal, state, and local quarantine or isolation order related to COVID-19. So does the, the California executive orders to stay home, which is our next slide, obviously that was a mandate on March 19th. Does that not qualify our employees for the first reason for the paid emergency sick?
No, it doesn't. I've had that question a few times. A quarantine or isolation order is when a county or a law enforcement official, when you're served with an order, or if you're in the hospital, you're already there and they put you in quarantine. But a quarantine order or isolation order is where you cannot leave your residence or wherever you are quarantined at. It's not like we're at, Illinois right now is basically the exact same orders as California. So we can go to the grocery store, we can go to the bank, you can go pick up takeout food, you can go pick up your medication at the pharmacy. That's not a quarantine order. That's a stay-at-home order that's advising us we should stay at home except for essential activities. A quarantine order is where you're not permitted, you're basically violating the law, and they can if you don't comply with it, they can forcibly make you comply with it and put you in a facility where you're quarantined, a medical facility where you're quarantined. That's a whole different ballgame. That's where you're not permitted to leave wherever you're quarantined at, period, for any reason.
Got it.
And I think the problem is,
oh, go
at
ahead.
the time this legislation was being drafted, apparently that Congress and the federal government weren't really communicating with the governors, because apparently they didn't anticipate that the states were going to issue these stay-at-home orders. So that's one of my big problems with this legislation, is it's sort of too little too late in a lot of cases, because by the time April 1st rolls around, we've already been required to shut down our business, or we've had to lay off people. And at that point, the paid sick leave doesn't really matter because there's no work for them. So I don't think they really considered stay-at-home orders for any circumstances under this, because it basically happened right around the same time, and I don't think they anticipated these stay-at-home orders. So if that had been, like, for instance, the other act we're going to talk about, where they have the small business loans, the one that's just being voted on now, they expanded unemployment, and there's a provision in there for if the business is closed down due to a publicly ordered health emergency situation. So they didn't really anticipate the stay-at-home orders when they drafted this, so it doesn't really account for that scenario.
But, I know that a lot of my clients that are on the line here right now, those that have been able to provide them, wages up until, the end of this month, and they may not be sick, and they may not be quarantined, and they may not be experiencing any symptoms, and may not have any kids that they're caring for that are out of school. But, they're looking to try and retain and keep talented people. Are you seeing that there are any forms, or, because it looks like a lot of people could qualify, but, could essentially some folks that are here on the call today kind of say, hey, we'll put you on this sick, but really they don't have these, they don't qualify for these 6 different categories here. Are you seeing any forms that our employees need to fill out, they need to qualify, and then therefore, report back on the payroll taxes?
Yeah, I haven't seen anything to that effect yet. There may be something out there, as we talked about earlier. The documents are flying out fast and furious on this thing. But again, as an attorney, I would, my legal advice would be, if they don't hit any of those triggering conditions, they don't qualify, and therefore paying them out the sick leave and then sending a certified request for the payroll tax credit subsequently on that, which I assume the certification is going to be under penalty of perjury. I'm certainly not going to advise someone to seek government credited payroll tax or payroll tax credits for a scenario that there's no qualification, because the employee shouldn't have gotten the leave in the first place. Whether someone tries to do that or not is a whole different question, but as far as legal advice, I certainly wouldn't advise someone to do that. One of the things that we'll be talking about is, with the other act, is the loans under the SBA, the Small Business Administration. And there are, I have to go through that act because I just got my hands on it yesterday, and it's like 880 pages. But based on earlier drafts, I don't think much has changed as far as the small business loans. That wasn't really a sticking point. And those provide for, part of that provides for payroll, and there's a loan forgiveness portion that applies to the payroll. So there may be options to get one of those federal SBA loans that covers the payroll, which would then be forgiven, so they wouldn't have to be paid back, at least the payroll portion, which that might end up being a better option than trying to put someone on paid sick leave that they don't qualify for.
Got it. Okay. And I believe, Fred, I'm going to unmute you. Fred Damavandi, he mentioned that he just recently spoke with EDD and might be able to share some information with us.
Hey, Toni, thanks. Thanks for hosting this. Very informative, appreciate it as always. Jim, thank you for your time. One of the true geniuses for the legal California, anything you need to know, amazing. So EDD had mentioned they still don't know how it's going to work with the new stimulus package, but they were recommending that. They talked about work share a little bit, so I have some notes on that, Toni. Maybe you can send it out later. But They really went into detail about how the work share program works, as well as employees that might qualify for many different things, whether it's they've been laid off or they're still working currently for a company with reduced hours. They just encouraged anybody that does qualify for unemployment just to get into the system to apply for the unemployment. So apply for unemployment, and they will do their best to triage you in the right section. They mentioned that they've been preparing for situations like this for a long time, and they learned from the recent 2008-9 mass layoffs that we had with the Great Depression, or whatever the terminology is. But they mentioned that it's taking around 3 weeks processing total time. So 2 weeks for them to receive the claim, process it, verify everything, and then a week to send it off to the banks, I should say Bank of America, for the cards, because they load up everything on a card, and then send it back to EDD, and then a week to get it back to you. So a total of 3 weeks, 21 days. They are working on the weekends, they mentioned as well. But right now the load is, I guess they've seen a 350% increase, they mentioned. Over 150,000 people have applied, when normally during this time last year, it was a third less. However, they said that reduction in hours, they laid guidelines out for that, the qualifications for that as well. There's a dollar amount. The information on the ADD website is really good about any information you need as far as the qualifications for each. But they did say something that was quite interesting, that if employees stay at home and refuse to work, how are they seeing it? They said they're going to deal with that on a case-by-case basis. They're going to request if there are medical reasons. They are going to consider if it's taking care of somebody that might be sick, or even consider, they didn't say anything specifically about children at home, but they said they will take it case by case, is what they specifically said, and see if they meet the qualifications. The tricky part is, they said, the drop-down menus currently for applying online, which they encourage everybody to do, they don't take that into consideration. So I believe it's, doing the best you can and calling them, because they are available and they're working their normal times. And they said that they've been transitioning a lot of the people that for this time that are able to work from home to work from home. So they do have people working from home as well. And that's pretty much the gist I received.
Perfect. Thanks, Fred. So just to go back quickly to, we were mentioning the executive order, and then also to a lot of our clients are actually still up and running because they're considered essential critical infrastructure. A lot of our clients are still in the industry of food services. I know that we had a question come up from one of our clients here, Jim, that maybe you can speak to this as well too. So we have some folks that are in food service. They are busier than ever. What do we do if we have somebody that does not work, but are healthy, but don't want to come to work just because of they provide them with the proper PPE and everything, but they just don't want to take the risk?
Well, there's a couple things there, and just to piggyback on something Fred mentioned, everything, all the information he provided there's excellent and completely consistent with what I've seen from the EDD as far as their facts and their information they're providing on this stuff. California has always had a reduction of hours provision for unemployment. So for example, if someone only is working 20 hours a week and they normally were working 40 hours a week, and you cut them to part-time, they could actually seek unemployment benefits for the difference, even though they're still working and still getting paid. Same thing goes for temporary layoffs or furloughs. So I would say in that scenario, a couple of things. Number one, there's no real legal right to say, and I've had this come up with a few clients, to just say, I'm just sort of paranoid about, being around other people right now, and I don't want to come into the workplace, even if we're an exempt profession or an exempt business. there's really no legal protection in that scenario. The employee is not exercising any legal right to stay home and refuse to come into the workplace. So there's nothing binding upon you as an employer at that point, because it's not a protected act. Like, for instance, if someone, you know, had an illness or something, or a medical condition or anything like that. So technically, you're not required to just let them stay home. You could offer them, you know, unpaid leave if that was something you were willing to do. You just didn't want to pay for it, but you were okay with them staying home for a few weeks.
Right.
And you wanted to keep them around and keep them, you know, on the payroll and keep them as employees. The other thing you could do is, if you were willing to allow them to stay home, you could get by without them, but you want to keep them around. You could just simply then furlough or temporarily lay them off, so that they could then seek unemployment benefits for that time period. Because as long as they're planning on returning to the job, you know, they'd still qualify, even if you haven't officially terminated them and they're still on the books and on the payroll. So that's another option. And certainly, if it came down to it and you needed them there and you were insistent that, hey, unless they have a qualified reason not to be in the workplace, they need to be here, you'd certainly have pretty good legal standing to terminate them at that point. I just don't know. That's probably not the route I would go right now. You know, everybody's sort of panicked, and everybody's sort of scared what's going to happen, and not just with the virus, but the economic part of things. And so I would say there's a big benefit in general to creating some sort of stability in the workplace and some sort of calm and confidence in the workplace. And so I would maybe give employees a little bit of the benefit of the doubt that maybe you wouldn't have given them a month or 2 months ago, especially if it's somebody who's a good worker, somebody you want to keep around, things like that. So I would say, yeah, I theoretically, you could tell them, sorry, you're not permitted to stay home. You have no qualified reason to stay home. You're required to come in. I just don't know if I'd draw that line in the sand if I didn't have to. I'd probably try and, you know, if it's going to be a short enough period of time, you know, a week or two, maybe give them unpaid leave or temporarily furlough them so they can get unemployment for the week or two.
Okay. So Jim, we have another question. It says, the California stay-at-home order, the orders for those over 65 years to stay at home are not triggering events under the FFCPA. I think you probably mean RA.
Right. So in the way it's worded, are we talking about the state one or are we talking about a county one? Because I know LA County and some other counties issued their own as well.
Oh, well, who this is from, they're in a bunch of different counties. So probably, you know, for talking purposes, we go for California.
Yeah, because I'm not seeing it I'm looking at the California state one, and I'm not seeing.
And I can maybe unmute her, and she may be able to. Let me grab her. Jihoon, are you there?
I am. Can you guys hear me?
We can. I unmuted you. You have free reign. So can you clarify your question for Jim?
Sure. Prior to Governor Newsom's state order requiring all California residents to stay at home, maybe a few days before, there was, I believe, an executive order, again, strongly advising anyone over the age of 65 to stay at home because they were an at-risk population. So I just wanted to know if that was a triggering event under the Families First Act, and if it was, how that differed from the general stay-at-home order now in effect for all Californians.
Okay. I should have known it was Jihoon because she always has really good questions. So there's a couple things at play, and this gets back to what I said earlier about the fact that I don't really think Congress contemplated at the time that right as that they were putting together this bill, all these stay-at-home orders were going to come out. So they didn't really provide for that. I'm not sure how that happened, that they weren't aware this was going to happen in all these major states, but it doesn't really do a good job of harmonizing with the stay-at-home orders. If it's I'm not seeing it in the particular order, stay-at-home order Newsom issued. I'd have to look at the exact language of either the LA one or a prior one that quoted the language you're talking about. If it's a recommendation, then that's not going to trigger under this particular scenario. If it's the way in the exact language of the statute that was put in place, it's a quarantine order. So that's going to be something where a particular person has been ordered by, say, the LA County Department of Public Health orders the person under quarantine. It's a lengthy it's like usually like 5 or 6 page documents from the CDC or the County Department of Public Health that is specific to that person and saying, you are suspected of having such and such disease, or you've been exposed to it, or you've tested positive for it, or whatever, and you're ordered by law to stay in, whatever, then they designate the location you have to stay in. I don't believe that would qualify under the particular stay-at-home orders, because again, if that person's still able to go to the grocery store or pick up their medication or whatever, that's not a quarantine or isolation order under federal law. That's a recommendation or a requirement that you stay at home except for limited circumstances. Generally, isolation orders and quarantine orders do not have any exceptions. You must stay in, like for instance, if you're quarantined at home, it'll have your address on there and it'll say you must stay at this residence at such and such address until such and such date. Under no circumstances may you leave, basically. So I wouldn't equate anything I've seen the San Francisco and LA County ones, and then the California one and the Illinois one. They all kind of mimic each other because a lot of it's based on the federal guidelines from either the CDC or the Department of Homeland Security as far as the exceptions for exempt businesses and things. So they all kind of are consistent, but yeah, I don't think it would qualify. I think in that case, you'd be back to, if they have sick leave time or paid PTO on the books, you could let them take it, or they could elect to take it. Short of that, you're either voluntarily carrying them on the payroll, or you or have them just temporarily furlough them so they can apply for the unemployment. And now the unemployment, as we'll talk about, this federal government is passing, the bill that's being voted on right now pushes that way up. I mean, the max in California is going from $450 a week to $1,050 a week. So as soon as that bill kicks in, it'll be a lot more advantageous for somebody who's out like that to get unemployment than it will be today or last week.
Okay, so we're going to get going here. We are on page 9. We have a lot of questions. So I'm going to run through these slides here so that way we can give one-on-one attention, and maybe you may need to give us the quick highlight overview, Jim, response, because everyone has a lot of specific questions pertaining to their specific needs and stuff like that. But quickly, I'll go over, you all have the slides here. When we're thinking about layoffs, you do have to keep an eye on the Federal Warrant Act, California Warrant Act. Recently, Governor suspended the 60-day notice. For obvious reasons, this came fast and furious, and we realized with the closure of schools, businesses, and layoffs, employers just could not provide enough notice, just because this isn't something that was foreseeable as well too. A lot of people have questions in regards to a layoff versus a furlough. One of the things that we're seeing on our side is we're getting massive amounts of information from the carriers right now, insurance carriers. Employees are very, very fearful of their benefits. God forbid, I have symptoms, I need to get tested. What if I come down with the virus, and will I have insurance to recover from this? And so a lot of carriers are actually putting in specific language in regards to layoffs and furloughs. This is just kind of a quick overview of it. I know many of you are planning next steps on how to manage, and the unfortunate need to make reductions. Well, I know it's tough to let people go. Many are struggling to try to retain the talent pool. I was on a webinar today, and they said let's try and almost see it from the other side. What would our talent pool look like if we had to reopen, and who would we just be devastated if we lost? So I do know a lot of people that they've groomed and they've recruited. They would like to retain them if and when we come out this other side, but also too, is there a way, an option to keep their health benefits in place as well? So I know many of you are looking at layoffs and furloughs, and I know there's a lot of definitions out there in regards to, is it a temporary layoff? Is it a permanent layoff? Is it a furlough? But what I've been seeing recently here too, is a lot of the language, specifically, I got one from Kaiser today, in regards to if you do have people on furloughs, that if you pay your bill, they're fine with that as well too. So I know as you're kind of looking at scenario, you know, level 1, 2, 3, 4, those are kind of different ways of looking at it. This is a benefits chart. You do have the link to it. There is a hyperlink to this as well too. So if you open it up, it's a PDF document. This is just your cheat sheet, right? And a lot of people think, well, they have to be terminated to actually apply for unemployment, and that's not the case. It would be considered partial wage replacement. You're going from full-time to part-time. You're on a furlough. So know that just because you are putting someone on a furlough, they can still collect unemployment as well too. And one of the things that Jim wanted me to add was that additional $600 per week, up to 16 weeks per emergency federal legislation. You know, I don't know if your employees are listening to the news. I don't know if they understand this. I'm not quite sure if they're going to be, you know, if I'm going to get more than what I was paid for before, if they're just going to be like, can you just terminate me or lay me off right now as well too. So we are going to see some, I think, some different conversations as well too with our employees. But the one thing that I'm seeing is a lot of people are very fearful of literally losing that talent base, and trying to retain them as much as possible before having to just totally do a layoff and then send them off totally to unemployment as well too. Jim, do you have anything to add in regards to this benefit chart here at all?
Yeah, just a couple things on the real quick on the slides you just went through.
Sure.
Just to mention on the WARN Act, California did put the temporary exception in, getting rid of the 60-day notice for a coronavirus-related situation, including the shutdowns, which now tracks with the federal WARN Act, which has an exemption that would cover this sort of public health emergency. There still has to be, you still have to give a notice to the state and to the workers. It doesn't have to be 60 days. It just has to be as soon as you know that you're going to shut down. So there's still a couple hoops to jump through. It just doesn't, you don't have to do it 60 days in advance. And then on the benefits, and this is on the EDD's website on their FAQ, it tells employees, if you're keeping someone as an employee and you're just temporarily laying them off or furloughing them, they should tell the EDD that it's due to a shutdown or a partial, or a reduction in operations because of coronavirus. That individual then, and that they're intending to return to the employer, because in that scenario, they don't have to do the normal work. Normally, an employee on unemployment has to seek other work, and every week they have to provide names of places they've applied to and all those things. If they're planning on coming back and you're planning on bringing them back, they don't have to do that. So they just need to let EDD know it's either a shutdown or a reduction in operations because of the coronavirus situation and the stay-at-home order, and that they're planning on returning to the employer. And then not only do they qualify for the benefits under unemployment, but they don't have to look for other work, which if you're planning on bringing them back, you don't really want them looking for other work for when they return. And then one last thing that Toni had mentioned, some people might actually get more under this. That was one thing that almost held up this bill. The reason why was they just did the flat 600 is because they didn't want to put a ton of pressure on these state unemployment offices, which are already swamped right now, to have to do all these convoluted calculations as to like what someone's average pay was for the last year to figure out if they're going to get a little bit more per week than they would have otherwise. But it's not the employee's choice, it's still your choice. So an employee could say, hey, I wish you would just lay me off so I could get an extra $50 a week from unemployment. But if an employee can't just quit and I had this question come up. They can't just quit and say, well, I'm just gonna lay myself off because I'll get more from unemployment. That's not really their option. If an employee quits their employment, they're not eligible for unemployment. So yeah, sure, an employee could ask that, but they can't really, you know, if they just do that on their own and you didn't lay them off, they're not going to even qualify for unemployment at all. So that's really something you may think about or consider, but it's not something the employee can't really force your hand on that.
So here's our new reality. You know, with the stay-at-home order, many employers are sent their employees home to telecommute. I know I have a full setup here. So this just totally changed how we do work. I do know that with some of our clients, they have maybe a very skeleton crew there, but it's really, really, really important to set up your telecommuting policy, setting up that arrangement, making sure that there's agreement. Do they have their phone set up? Do they have a computer? Do they have Wi-Fi? Do you know what their hours are as well too? With some people that are actually at home, are they fully working, or are they really kind of taking a leave of absence as well? So making sure that you have that set up. Lines of communication are incredibly important right now, whether it be, you know, you have a group me or you're texting each other. You do Zoom meetings as well. Communication with your team, setting expectations. You know, for those of you that are totally paperless, bravo to you. We never knew that we'd be in this situation. So those of you that are paperless, you have everything virtually. So you're ahead of the game. For us that have some of it online and some of it via paper, it's been quite a challenge for us. But setting up that communication tree, are you having leadership meetings? Having a web camera has never been so important as well now. Systems in place. So, you know, access to everything right now is critical. So some of you that may have a little bit of time on your hands, really cleaning up that server, making it accessible. So we aren't going just across the way and going, do you know where this file is? Do you know where this is? We're not going to be able to bother and talk to our coworkers 20 times a day. So it should be simple, process driven, and accessible as well too. Again, we talked a little bit about those telecommuting agreements, making sure you know when people are going to be online, they're clocking in and out correctly. Also too, if they're hourly, making sure they're taking their rest periods, their breaks as well too. And at the very end, their home office. So, you know, are people just sitting on their couch and could create a carpal tunnel situation? Are they looking at their TV the whole time as well too? You know, it's going to be our new reality. Hopefully not for months and months and months, but what if? So, you know, we just watched leading a virtual leadership team, and it was really eye-opening in regards to setting up the home office. If you have children around you and you're homeschooling them, making sure that they know that this is time where, you know, you have your 90-minute jam session to do some work, and if the door is closed, then the door is closed. We're either on a conference call or some sort of webinar, and I'm not accessible right now. So making sure you have those boundaries, but also too, making sure you set up yourself for success. And, you know, do people have the right chair? Do they have the right setup? And could there potentially be some issues where someone actually might get hurt because of their office setup? So please, I don't want any of my clients to be calling me with a workers' comp question in regards to that as well too. Insurance. So what we're seeing right now, you know, one of the most important items these days is health insurance. We've been getting some very, very concerned calls from individuals. Either they're worried, they're getting tested right now, they are in quarantine, they're being seen by the CDC, and the conversation of insurance has never been so important to employees and employers, either to get tested, treatment, or to use the telemedicine to be cautious. We know it's very important, however, we know how expensive it is as well too. And so I know a lot of times people are considering cash flow, keeping people on, and then what happens to the benefits as well too. every single insurance carrier is now coming out with their own FAQ. There is a lot of flexibility right now in regards to enrollment, opportunity to downgrade a plan, opportunity to, not pay your bills on time, okay, giving you some wiggle room per se in regards to premium payments. Also too, a special open enrollment period right now too for people that either decline coverage or didn't take it at open enrollment. There's that special open enrollment period right now too for those that feel that maybe they need it now more than ever. So we are kind of following the lead of the insurance commissioner. He's been very, very busy kind of putting out these mandates for insurance altogether. But one of the things we've seen is the 60-day premium grace period. We've also seen the special open enrollment period. And then what we're doing is we're gathering all the information specifically from the carriers. So if you have Kaiser will have their document. If you have Blue Cross, they have theirs. Anthem, they have theirs. And again, a lot of them too say call your account manager. If you want to downgrade your plan right now or put an additional downgrade plan, this is the time to do, because they want to be flexible with you. And also too, they know that in this time that they may be losing membership, but they also too want to be there for you to provide some coverage that maybe you didn't put in place before. So always make sure you're taking a look at those things as well. We are seeing flexibility, coverage. Make sure people are using their EAP, employee assistance plan. And then also too, we are seeing a lot of people talk about life insurance. We are seeing people asking, can I bump up my life insurance right now? And I go, well, there is a there is a little medical questionnaire that goes with it because you passed that open enrollment time. But we are seeing a lot more conversations around that as well. And I'm going to give you an example of what we're seeing from the carriers. So you'll see this one from Kaiser. You'll see this one from Anthem. I think Anthem's is 16 pages. I think Kaiser's is about 12 pages. Blue Shield, Anthem, UHC, they're all coming out with different things. And I believe I just saw something recently from Aetna. So Aetna and CVS have a partnership, and they're working on self-test kits being available at CVS and being covered at 100% with Aetna because of that partnership or ownership as well too. So for those of you that are our clients, you will be getting the latest and greatest from the carriers. There are some exceptions to certain things, and we can work with you and talk to the carrier as well in regards to some flexibility, and if you want to make some changes to your plans as well too. So keep that in mind, that they're definitely working with people right now too. And one other thing that I forgot to talk to you about is they do talk about layoffs. They talk about furloughs, especially with the Kaiser. They said if you pay your bill, you pay your bill. Are they going to be checking in regards to 30 active hours? Their stance on it, if somebody's on a furlough or a leave of absence, then as long as you pay the bill, they will honor that as well too. So again, for our clients that are with these specific carriers, we will give you their updates, and they're changing constantly as well too. In regards to Cal OSHA, workers comp, some of our clients still have people working. They're practicing social distancing. They're doubling down on training and making efforts to put up signs, remind people to wash their hands. The biggest thing that I've seen is don't touch your face, increasing disinfecting practices in common areas. And Cal OSHA actually has specific trainings that are here. They have specific posters and specific brochures as well too. So they've given it to us, put it all around, give it to people. And so it's just a nice reminder to folks, especially that those that are continuing to work in some of those essential infrastructures, that they are given this information. God forbid somebody contracts this disease while at work. I think it would be kind of a workers' comp conversation. It would be a Cal OSHA conversation as well too. But if you were able to say, hey, we've put up all these things and we've increased our PPE and our training modules, here's what we've done, and our housekeeping standards, It's something better than nothing. Also, too, you see here, declaration, no injuries. Why do I have that on here? So we talked a little bit about furloughs, and we talked a little bit about layoffs as well, too. Unfortunately, in 2000, when we saw in the last recession, a number of our clients got hit with CT claims and delayed workers' comp claims, as I call them. And so, unfortunately, you will have that, that decision to make changes within your company. It's just inevitable. And the last thing you want to do is say, hey, by the way, here's your last paycheck, here's your ADD information, and by the way, can you sign this? It is not a silver bullet. Some people go, well, if I have them sign it, I might be, planting the seed. Yes, you may be, but it's something better than nothing. We are in California and we side with the employee, but it is something that at least gives you peace of mind going, there was the last day. We had no knowledge of this injury ever happening. And if you have somebody's signature, it does help in regards to providing that to the adjuster if and when you do get claims for post layoff type of situations. I hate to even bring it up, but we see it time and time again. And hopefully that's something that you'll never have to deal with. So sometimes too, my clients kind of embedded in their exit paperwork, just so people go, did you have any work-related injuries? They say no, off you go. But also too, it says you got your last check, you got your COBRA information, you got your 401k information, and by the way, here's this last portion as well too. So if you can incorporate that, please do. If you don't feel comfortable, I understand that as well too. I was on a recent call the other day, and a lot of people were talking about payroll. So in regards to on the workers' comp, there is something called idle time pay. And so if you have been, you have a large amount of your staff that is on leave, sick, a furlough, it is considered idle time pay. So when you're paying your worker comp bill based on payroll, that would still be included, okay? So kind of keep that in mind in regards to idle pay. They're still employees versus being terminated employees, right? So furloughs, they're on sick, they're on vacation, all those different types of leaves, those are considered, and that would be part of your payroll as you look at the workers' comp and you look at what your bill would be for who's on that bill. Also too, with the insurance commissioner, he did state that there's a 60-day grace period for premiums, and how we've read that is that all insurance carriers in California. So we've been talking with the general liability carriers, the EPLI carriers, the cyber carriers, and also to the workers' comp carriers as well. And also what they're doing is making sure that they are giving some flexibility for clients as well. So know that that's coming as well. Many of you that came to our labor law update, you saw the folks that gave out the labor posters, our sexy, lovely labor posters. Those are the folks from Got Safety. And for those of you that are clients on here, you should all have access to Got Safety. If you don't, call me immediately because you need them. What they have on there, they've just updated. They have a coronavirus training, pandemic safety, cleaning, disinfection, so social distancing, personal responsibility for health in the workplace, and then hazardous material hazmat suits. So a lot of you need, they updating those that have people that are at home and they need something to do. Why don't you just assign them 12 of their safety trainings they should be doing for the year, and make sure some of these are there as well too. What they're working on right now, I'm very excited to see, is they have a pandemics return to work series. So there is a light at the end of the tunnel. Don't know what date that is, but there is. And at some point, your people will be coming back. Washing our hands is going to be the new normal, right? Not touching our face is going to be the new normal. I'm practicing my bowing because I don't think we're going to be shaking hands anymore as well too, okay? So that is going to be a wonderful series as people start coming back. And how are we going to be safe within the workforce to make sure this doesn't happen again? Also, too, for those of you that have put together all of your Cal OSHA, your 12 documents with Got Safety, for no cost, they will actually be adding in the infectious disease and response plan to your actual portal. So not only most of our clients have about 12 documents in there, you'll see this added in there recently. If you don't have all your safety documents, obviously you're worried right now about keeping the lights on, keeping your employees happy, and keeping their health insurance. If you do need them to put together your documents, they do the best job. It's proven itself against Cal OSHA fines and auditors, and then they're just adding that at no charge to our clients as well too. So again, if you don't have access, please let me know so I can set that up for you as soon as possible. Staying healthy. So I don't know about you, but you may be cooped up and going a little stir crazy. For your employees, you need to make sure they're taking care of themselves as well too. There is a company out there that has a free mental health exercises that I can send to you. Again, give some of your employees some mental stress management exercise. We also rolled out GoodRx with our clientele. We did a webinar last week. You know, God forbid you do have to lay somebody off and they don't have the funds or the money to go on to cover California or take the COBRA. You could actually say, hey, we have something called GoodRx. It's literally a discount app, and you can find out your cholesterol medication, where the cheapest place is to pick it up. And so we always advise people you could use it alongside with your insurance. If you are going to be taking maintenance medication and you're going to be taking it for the rest of your life, why don't you find out where the cheapest place is? So that's something that you can give out to people as a nice to have as well. We have partnered with Healthiest You. Healthiest You is kind of a concierge service. It gives you mental health, regular physician's visits, nurse practitioners. It's got a number of different resources. It's very cheap for people. Sometimes it's like $10 a month. Again, if God forbid your employees lose their insurance, I would direct you for them to go to something like that. One, if you have some medication, find the cheapest place. Second is you may not have health insurance, but you do have access to a doctor. Those are two things that are very inexpensive and something that you can give out to people as well too. I advise people, please, please, please use telemedicine. I think all of the carriers now have like dropped their prices on the telemedicine. I think anything that's related to the COVID-19 is no copays as well too. So, you know, please don't bog down the ERs and the urgent cares if not necessary. If you do feel it's life and limb, then yes, go, but you might be getting something worse than what you came in with. So I always tell people, if you can, do those push notifications to your employees to remind them about the telemedicine so they're not waiting 3 hours over at urgent care with a bottle of Purell as well too. Also too, we work with Great Perks for You. I believe that's what it is. Somebody's going to kill me. We've partnered with them. They actually have $100 kind of gift card for Postmates right now. So that would be nice to give out to your folks as they're cooped up at home. And like me, I'm raiding my pantry and trying to get creative with different dinners and lunches and stuff like that. And they also have a discount membership for Sam's and Costco. So I know that one of our clients is here on the call. They have some wellness dollars, and we're going to be looking at getting some gift cards for people during this time that are cooped up at home. So to help with the groceries, but also to for those folks that don't have a membership to Costco, how meaningful that would be as well too. So again, just what I try to do, and my team is on the call here, I try to send out inspirational messages at least once a week, every other day. Sometimes they're cheesy, sometimes they're not. But we really need to make sure we're touching our employees, making sure they're okay. We can't see them face to face, but also too, what are some cool things that you could be giving them as we're going through this difficult time that may not cost you a lot as well too, okay? Okay, so Jim, do you see this long laundry list here? So, you know, many of you that come to our events, you know, my motto is I scare because I care. And I do that because, and it's not really a joke, but I really want you to keep in mind all the other little monsters that are just around the corner. I know as you're looking at all these new laws and you're going, how the heck am I supposed to calculate this paid sick? And what am I supposed to do? This Yahoo doesn't want to come to work, but we have a job for him. You know, there's all these other things that we have to think about that surround some of our employment decisions and stuff like that. So I know you have a mountain of work. I know you're stressed as well right now. And this is the last thing you want to hear from me. But again, I just want to make you aware of what other legal considerations are out there. So, you know, in regards to layoffs, you know, what system are you using? Or is it first in, first out, based on seniority, based on the last performance reviews that hopefully were accurate? Avoiding discrimination claims. If we're trying to force people to use their sick and they're not, could they say it's retaliation? There's also ADA, FEHA. We also have a paid family leave through EDD as well. That we also have a school closures a leave already. We have our already FMLA on the federal side. We have our CAFRA on the California side. The wage and hour is going to be very, very tricky right now in regards to setting up properly in your payroll and making sure that you're calculating the wages correctly as well. The COBRA implications, harassment. What if somebody has been quarantined, they're okay, they come back and everyone says, I don't want to work with them. They're going to give me the virus even though they've got a clean bill of health. Could there be that? Affordable Care Act, you know, for those people that are working 30 hours, are we providing them with a minimum essential benefits and it's considered affordable? And then the wage statements. I mean, I have no idea what these wage statements are going to look like and if they're going to be compliant at all. So, you know, we can't be compliant in everything. I think going down this road as we're looking at big picture and some of our employment actions, we just always need to remember what else is out there and kind of take the road that is the less risky with the least amount of exposure. I always tell people that before you pull the trigger, call me, call somebody like Jim, okay? Or call the 800 number on your EPLI policy just to kind of get that, I just want to triple check. I just want to triple check to make sure I'm not opening up 10 other cans of worms as well too. Jim, any feedback on this slide as well too? Is there any that you're seeing that could possibly be a bigger risk than others on this list?
Yeah, just a few things, a few quick points on some of the stuff you covered, which sort of dovetails into this list. And I like your I scare because I care saying, so I'm gonna come up with one right now, which is every dollar of prevention you spend right now will save you $100 in legal fees down the road. So when you don't check with Toni or me or some counsel or somebody because you want to try and save $1, it's going to cost you a lot more down the road if you don't do it correctly. I've seen that play out time and time again, and with this sort of emergency legislation, that's probably more likely now than ever. But a couple of quick points on the working from home. As someone who litigates employment lawsuits, the two big areas that would concern me are something Toni mentioned, which is the hours. Make sure they're recording their time in, their time. This is for hourly employees, of course. Make sure, or non-exempt employees, make sure they're recording their time in and out for the day, their time in and out for meal periods, that they know they're supposed to take their own rest schedule and take their own meal periods and rest breaks. And if you don't have the ability for them to log into a server to record those times, you can give them just sort of a create your own timesheet, or you can have them simply email daily the times in and out to the payroll person. It doesn't have to be a sophisticated system put in place if you don't already have an ability for them to log in and do that. Expense reimbursements could be a big issue because when people are working from home, if they have to buy equipment, they have to buy supplies and things like that. I think you really need to tell people who are working from home that they need to let you know if they need to incur any business expenses, buying any equipment or supplies to work from home, and make sure that's done in advance before they start incurring those expenses. If somebody has to have a computer at home and they don't have one, and they go out and buy a laptop, you don't want them coming back and trying to bill you for the laptop when you could have just given them an extra one out of the office. As far as the health coverage, you know, Tony's better adept to cover as far as whether you can keep paying people who you put on furlough or leave. But as far as I did want to mention something as far as their share of premiums. If you are in that scenario where you continue to cover them while they're out and they have a share of premiums that they need to pay, you can either have them prepay it to you. You can just sort of bill or invoice them the premium as it comes, or you can have them. You can defer it to have them pay it out of deductions from future pay when they come back. To do that, you have to have a written authorization from them, though, to make that sort of payroll deduction. So you do have some options there if you set up that sort of scenario, and you know, you still need to get the premium payments. And then as far as the health part of it, one thing that I see come up with a few employers that maybe they don't think about is, sure, you know, to wipe down, you know, your door handles and clean your bathroom more often and your counters. A big thing for a lot of people is tools and equipment. In a lot of workplaces, people share the same tools or use the same equipment. So you want to try and limit that as much as possible. And if people do have to share the same tools and equipment, make sure those things are being wiped down, disinfected, etc., before the other person's using them. And then as far as the wage statements, to me, the tricky area will be on that. Make sure if you are paying any of this special paid sick leave or paid family leave, that it's its own separate line item on the wage statement. Because we already in California have paid sick leave for everybody. You don't want to mix that up where it's unclear whether you're paying their sick leave that comes off of their sick leave balance with you, or this special sick leave that's getting, you know, reimbursed through a payroll credit. So however you designate it, just make sure you're paying those as separate line items so that you have evidence and proof you paid the person that particular time. And it doesn't mix up whether that's their other sick leave or their other PTO or this special leave. And then one last thing on the declarations of no injury. They may not necessarily be 100% enforceable. Someone may come back and say, oh, I didn't really sign that, or that's not my signature, or they made me sign it. The only thing I would say about those sort of declarations, especially with the final paycheck, is you always want to be careful. You cannot withhold their final paycheck requiring them to sign something like that. No. Number one, you'd get in a lot of trouble. It's unlawful under the labor code, but it's also unenforceable. And even if that's not your intention, sometimes the people handing out the paychecks don't realize that. So I've had that scenario where the people handing out the paychecks are telling people, you have to sign this to get your paycheck. So just make sure anytime you have anyone sign anything, any type of statement, that you're giving them along with their last paycheck, that it's made clear to whoever's handing out those paychecks that it cannot be a condition that they sign those things in order to get their pay. That's something I do see pop up periodically, and that's just something you don't want to get yourself in trouble with that.
Do the people really do that? Oh my goodness. Never
Well,
thought about that.
well, and the problem is it depends who's handing out the paychecks. So sometimes you may have supervisors go at a store handing out, distributing the paychecks, and they're not payroll people, so they don't understand, you know, that they're not supposed to, that if the person refuses to sign it, they still get the paycheck. And so, and you also sometimes get people that may just claim that, you know, I was told I had to sign it to get my paycheck. That's the only reason I signed it. You just want to be really careful with that it's clear that, hey, if they don't sign it, that's fine, and you know, they get the paycheck. And certainly if it's an injury situation, if they say they're not signing it, then you ask them, well, what was your injury? You know, and then you'll deal with that issue right there. But
Right.
That's pretty much it. I mean, the rest of the stuff you've got there, I mean, it's sort of, you know, we could spend a week going over all those categories as far as all the standard California requirements. California's got a lot of regulations and laws when it comes to employment. So,
Jim, yes, you know, obviously has disability. We have the, you know, accommodations form that we have in California, and you go through the process, right? And we have an actual doctor sign off for family medical leave, and we have medical certifications for somebody for the paid sick, the emergency paid sick here, you know, having symptoms like do we just take their word for it? Is that, I mean, like, I have a little tickle in my throat, and obviously people run for the hills when they see me. But, you know, technically I have kind of the symptoms or whatever. Is it more of a honor system to say, you know, here are the different criterias if people really want it? Because there is no particular form right now, and I highly doubt people are going to be able to get a doctor to sign off on that. But are you just seeing that it's an honor system for the paid sick?
Yeah, I think it's going to have to be the honor system.
Okay.
We're in, you know, and I started practicing in March of '98, so we're just now hitting 22 years, and I've never seen anything like this in employment law. I mean, we get changes daily with new cases coming out, things like that, but I mean, this is just unprecedented times. And I think, as always, you're better off erring on the side of being conservative, because you certainly don't want that person in the workplace. You don't want all your other employees panicking about being around them.
Right.
Like you said, it's not, they might have trouble getting in to get a doctor to sign off. What I would say is probably, particularly because this paid leave, we would be requesting then a tax reimbursement, or I'm sorry, a payroll tax credit, and we have to provide certification and documentation to them. So I probably want some paper backup, but I don't know that it needs to be anything sophisticated. Frankly, if they just email whoever's in charge of HR and say, this confirms that I have had, you know, I've got a cough and a fever or whatever, and therefore I'm, you know, requesting to go on this federal paid sick leave, to me, that's fine. As long as there's some documentation that we have something in the file, we can go back and say, you know, on this date, this person indicated that these symptoms and requested the, you know, the paid leave. I don't think it needs to be anything fancy, because we're going to be on the honor system too, because we're going to be submitting the certification to get the payroll tax credit. So we're going to submit the paperwork, and that's going to be kind of taken on its face. It would just be good to have some sort of backup somewhere, and even if it's, like I said, it's just an email, or if you want to create your own little form, or just have them, you know, type out a one-page, you know, or one paragraph document on a piece of paper, whatever it might be. I'd probably try and create at least some sort of minimal paper trail that documents the reason why. I think I always tell people, these are always tricky, because even without this situation, you know, I get people that say, I don't think this person's really sick, you know, it's too convenient on a Friday. I think they just wanted a 3-day weekend. And I always tell people, you know, your job is to be the employer, not to be a doctor. Like we're not gonna be, you know, like on one of these TV shows where we're investigating, you know, or doing some sort of medical investigation into why the person's out. At a certain point, you have to take them, you know, on its face when it just comes to more minor things. But certainly, if you ask too many questions, you might get too many answers, because you start asking a lot of questions about their medical condition. They might start disclosing things that now start triggering the ADA, Americans with Disabilities Act, FIA, all sorts of other protected medical laws that sometimes you don't want to get too much information when it comes to their medical condition.
Right, absolutely.
So,
thank you.
Because that puts you, then now all of a sudden you're on notice and you have obligations. So I would say, yeah, I mean, we kind of have to take people at their face value, especially because if they're wrong, they could get other people sick, not just themselves. So, you know, that would. Well,
I think I'm going to put together and create a sample form for clients if there isn't already one out there. So, I'm going to be, we have 2 resources that I watch religiously. One is the John Hopkins map here. It's somewhat addictive, but very informative at the same time. I do watch the news, but I try to limit the news as well too. There's 2 documents that I just have been glued to, and this is just a real-time mapping of confirmed, but you'll also see deaths here. And then I don't really see that they report this on the news at all, but there actually is. They actually show the recovered as well, which I think is a good number. So I love this. It is embedded into the PowerPoint. So if you click on it, you'll actually be able to go directly to that. The other document that I find is fascinating is the Bain & Company CEO plan for coronavirus actions to take now. This here is just packed full of information, whether, you know, what it is with their people, your P&L, your revenue, your operations, your costs. They also have some information in regards to kind of where are we, you know, in regards to the GDP around the world. And then also too, they actually kind of map out your war room. Now, you know, obviously this is pretty intense here, but in regards to just setting it up, what would it look like, and what are some of the critical actions as well too. So those are all on your resources here. Again, we have them embedded. Again, I like looking at this all the time. I saw that we were third, and then I guess in one day we became first. So I guess we are number one right now. But I also do kind of focus in on the recovered numbers right now as well too, to kind of help me out. We have a lot of federal resources here for you. So most of what we put on there, you have on here as well too. Your California resources, working remotely resources as well too. And we got some of these from Don Finn, who's a hilarious attorney. Here's some lawyer groups, some HR groups for some great information. These are some sample HR policies as well. So we talked about telecommuting checklists, and some agreements as well too. So these are all hyperlinks, so you can just click on those and open up those documents as well too. One of our clients called the other day. She's Hiromi, she's wonderful. She has some exempt employees that are at home. They're not actively doing their job because they're maybe on the F&B side, food and beverage. And so she's taken this opportunity to actually get them trained up on onboarding, on critical conversations with employees. Also too, knocking out all of her safety required trainings and creating, it's called a learning track. And so they have so many months, weeks, years to complete these. So I know a lot of you, I bug you, I'm your nag when it comes to safety, because if and when Cal OSHA does come, or if and when we need to talk to carriers, I always want to put together kind of a brag in regards to your risk management, but you're always so busy. So you may have a little bit of time right now. So why don't you do those projects that you've always been putting aside, but also too, the required trainings. This is a great opportunity for just to knock these things out, whether it be your 2-hour management harassment training, just knock it out. And then also too, this is an opportunity for your managers to actually, you know, hone some of their skills, whether it be advanced Excel, in regards to, you know, how to hire, how to fire, you know, motivating your team, setting goals, those types of things as well too. So put together a career track. And then also too, you know, those that are in hospitality, there's a lot of third parties that are allowing you to use their services for free for a month. Why not prep your staff that you still have, get them ready for when you are able to come back. So that way they really utilize this time efficiently as well too. So I think, like, while we've been on this webinar, I think this has passed, I believe, Jim. Not quite sure. But this is just a quick visual of the $2 trillion coronavirus act, and you'll see just the different breakouts of all of this as well too. And I know a lot of people are going to be looking at the extended unemployment, and then also to the individual payments as well. Jim, did you want to touch base on this at all? Because it's just kind of coming through.
Yeah, just briefly on the a big one that I've gotten a lot of questions on is the small business part of it. So any employer who has less than 500 employees, there's a provision in there for small business loans, which would cover rent, operating expenses, utilities, prior debt obligations, like if you had a line of credit or something you're paying on every month, and payroll, potentially up through the end of June. And the payroll portion, and I believe possibly the prior debt obligation portion, can be forgiven, but there's a discount on that based upon layoffs. So they look at how many people you employed last March to June compared to now when you apply for the loan. So let's say, or for during this covered period. So let's say you had 100 employees and now you're down to 80. Then you only 80% of that, the payroll and prior debt would be payments would be forgiven. So there is a little bit of an incentive to not lay off people and then the payroll part is covered. And there is a built-in deferral of up to 1 year on the payments. And if anyone buys the loan, it's set up so that the federal government can basically step in and buy the loan instead to guarantee the 1 year in deferral, or up to 1 year in deferral payments. And I know there's certain procedures being put in place to sort of fast track these loans. So I know both the Small Business Administration, the SBA, who the loans are through and are guaranteed through, and then the lenders are already starting to work on the paperwork on these loans, even though the bill is not officially taken effect. So if you think you need any type of loan or short-term loan to cover operating expenses, payroll, things like that, I would immediately call the Small Business Administration and your lender and see what, they'll be much more informed about all the technical requirements, but I'd immediately hop on that and get that process, start exploring that process, because they're trying to fast track those loans, because they know people, need these to stay in business. And if you go out of business first before it gets to the loan, then it won't really matter. So that's sort of a big thing for anyone under 500 employees that's coming out of this particular bill here.
Do you see that nonprofits are eligible for these for this program at all?
Yes,
I know
yes.
880 pages, but
yes, nonprofits are specifically included.
Okay. I do know that I was on a club webinar this morning, and I guess 501c7s are not, but those are for like private clubs. But in general, nonprofits are. So if you are a nonprofit, you'll want to dive in a little bit deeper in regards to all the language. But I was getting text from people saying that they did pass this. I don't know if they've made any revisions to what was previously sent over. So Jim will be very busy with, is it 880 pages, Jim? Is that what it is?
Yeah, thankfully some of that stuff doesn't really apply to what I do, so I'll be ignoring a few hundred pages.
Fantastic. Oh, smart man. So quickly, what I did is, all of you that are on this call too, forgive me. Again, I need you to have two things. I need you to have got safety, the safety experts, and I also need you to have Think HR. If you're a client, you need to have both of those things. If you don't have it, shame on me. We'll make sure you have them. What I did is I grabbed their latest and greatest in regards to questions that have come in. A lot of you use them as a backup to me. If I'm not available, or you just need something quickly, or you just have, it's a repository of different forms as well too. Some of these questions I thought were pretty poignant, and some of the questions that I've been hearing from people. So do we still have to provide the paid sick, the leave if we have layoff and furlough employees? And basically they would not qualify. Our businesses suffering due to, go to the next page. Our businesses suffering due to COVID-19. We can't afford to pay people right now. What should we do? So again, in looking at, is it a furlough? Is it a temporary layoff, or is it a permanent layoff? And they have some definitions there as well too, and taking a look at that. And then where do you guide people in regards to their health insurance and unemployment as well too? So that is going to be kind of complicated in regards to kind of putting people in the right category for what their situation is, right, Jim? Because if they're sick, is their child sick? Are they caring for somebody? Is it a school situation? Not only do we have these new emergency laws and leaves, we also have that long laundry list that we showed as well too. So you could have somebody that is already sick, and then they're already on some sort of disability leave or what have you, and they also could get sick. So everybody's situation is a little bit different. And I do agree with you, Jim, that there needs to be some sort of like little form that they would check off, kind of like a leave of absence form, whether it's bereavement or jury duty or what have you, just checking off why they're actually going to be gone as well too. Can we reduce paid because the economic slowdown due to COVID-19? Jim, what I'm hearing for a lot of people is, I want to keep my people. I want to stay connected with them. I want to keep them on as long as possible. What I am hearing from people is, I would hate to do this, but would I look actually reduce pay? So I grabbed some information, exempt, non-exempt, reclassifying people, and any feedback in regards to doing that? Are you seeing anybody doing this as well too?
I haven't yet. I have clients who've been talking about it. Unfortunately, right now, it's, number one concern is, can we stay in business and keep operating? And number two is, can we even afford to keep people on the payroll, period? So everyone's sort of scrambling to come up with all their options. I would say on that first point there at the top, in California, as long as it's an at-will employee, if it's a contract employee that has an agreement, for a 2-year contract at a certain rate, you're not going to be able to reduce that. But as far as anyone that's at will, which would be most employees, the California Labor Commissioner takes the position that as long as you just have to give them one pay period notice. You can't change the pay during the pay period.
Right.
And then once you give them notice, it's an at-will employee, so basically you've offered them continued employment at under different conditions, and if they keep working, they've agreed to the new conditions. One point that goes back to those SBA loans, though, I believe there's some language in there that also says something like, as far as determining whether the amount that can be forgiven of the payroll can be forgiven, the part that says it'll be reduced based upon layoffs, I think it also can be reduced based upon, they count employees as well whose pay is reduced by more than 25%. So I believe if you're trying to seek that sort of loan to cover payroll, I double check with that with the SBA and the lender, because there may be some condition as far as how low you can lower their pay to basically get that payroll covered. Because if it's not, if you go beyond, if it's not, the further you lower that, the amount that's not forgiven, that's the amount you're going to have to, pay back. So there is a little bit of interplay with that SBA. There's always, the sort of diplomatic questions of, people aren't generally happy to find out they're making less, and particularly not in these circumstances. So those are sort of case by case, and your employees better than anyone else. And what I've been telling people is, if it comes down to it, if it's a matter between keeping them employed and keeping the doors open or lower pay, I mean, you just got to sort of approach the fact of, hey, we're all in this together. Like, we're trying to keep the business open and keep a job for you, and we all have to make some tough choices right now. And I think most people, won't necessarily like it, but they'll be sympathetic to the reason why, you have to make some changes to keep the operation afloat.
Absolutely. Thank you. And then also too, I just put on here, how do the emergency FMLA and the emergency paid sick relate to each other in regards to caring for children? So this kind of maps it out a little bit. You already talked about it as well too. It kind of you start with the sick, and then it rolls into the FMLA after that as well too. On a positive note, I know we're kind of all in this together. I'm sometimes reminded that we shouldn't be looking at the news 24/7. Why it's never positive, but this is really a great opportunity for all of us to help each other. There's a nonprofit called Because I Said I Would, and it encourages people to help others by honoring their word. And I'm part of this, and so they have kind of individual actions, right? We kind of have to come together here to fight against the COVID-19. I personally love the Helping a Senior with a Grocery app. So where I live, I do have a neighborhood directory, and I have a lot of seniors that are around me, and they're cooped up and everything, and I'm not even quite sure if they talk to their family as well too. So I'm, for all of us that are there, I know we're looking at payroll and the sick, and now the poster, and then now we got to get a form, and the furloughs and benefits and something like that. We're always a little stressed right now, but in regards to just, stepping back, how can we give back? Those are some things that I'm going to be doing. If any of you are interested in it, it's like I said in the top there, Because I Said I Would. But this is an opportunity to thank the people around you, your loved ones, your community, your family. One, for myself, I'm so blessed and honored to have such amazing staff. All my clients that are here on the call as well, I want to thank you for being our clients, some 25, sometimes 30 years. and of course my family and friends. This is our opportunity to kind of come together as a community, especially during this crazy time. What I'm going to be doing though is, we're your protection partners. I know many of you have your legal eagle to put things together. Jim is highly recommended by some of my wonderful clients that are here on the actual presentation today. What I'm going to be doing is reaching out to all of our clients here. And if you need some specific one-on-one time, I was thinking about putting together little groups of 4, or maybe 3. If I have people that talk too much. We're going to call it coffee and counseling. And so we can brainstorm, we can help each other and come to, strategy with one another and support each other at this time as well too. So I wanted to let you know, we are going to be going over the questions now. I know some of you may need to hop on and actually take your meal rest periods right now. But Jim, if you don't mind, I'm going to be going over some of these questions. I have a couple of repeat offenders here that maybe I'm just going to have them actually talk out loud, maybe.
Tony, can I stop you for 1 second?
Yes.
There was a question earlier about, as far as like, do I pay overtime with this paid sick leave? And I actually looked up the answer to that question while we've been going here. So I do have the answer on that question from earlier.
Fantastic.
It's if the FMLA paid sick leave part is, yes, you would include overtime if the person normally works overtime. Like for instance, if they're hourly and they're scheduled to work 45 hours a week normally. Not the paid sick leave part, because that's specifically capped at 80 hours. So no matter what their schedule is, and if they work overtime, it's still only going to be a max of 80 hours. We generally call it 2 weeks because as a full-time employee, but it's still 80 hours is the cap. And then the regular rate of pay, as far as they calculate it federally, is to pay that time out is based upon their average rate of pay for the prior 6 months, which would include any commissions, bonuses, things like that. So basically, you'd calculate their last 6 months, like take their total wages, divide it by the number of weeks, divide it by, if they work 5 days a week, divide it by 5 days, and that's like their average daily rate. Same thing with the hours, you just keep dividing it down so you got the regular rate. And then if it's less than 6 months, then you use whatever it's been. So if it's been 4 months, then you use the the full 4 months. So that's basically how they calculate it federally as far as how that's paid out.
Perfect. Okay. So we have I have Miss Karen. I'm going to unmute her. Karen, can you hear me from Storm?
Oh, yes, I can.
Miss Karen, I see all of your questions. Which one is the most important? Which one would you like to ask Jim about?
You've answered at least one of the questions already. I think my big thing is just going back to this overtime business, because we're talking some pretty big shenanigans on our part to make sure we understand what the person's worked on average. So if I understand correctly what you're saying, if the person normally is scheduled for 40 hours a week, but in practice in the last 6 months they've worked overtime, we actually have to go back and calculate what they have worked each week for the 6 months, and then divide by the number of weeks. And if it's on average 41.2, that's what we pay out for the first 2 weeks of the emergency sick leave.
Well, it's slightly different than that. So for the actual hours, so for instance, with the sick leave, it's going to cap at 80 hours regardless. But for the FMLA, it's it's up to 10 weeks paid out of the 12 weeks. So for the week, to consider it a quote unquote week, what they say is it's based upon the hours the employee would have normally been scheduled to work. So that means you don't really have to worry about what they did 3 or 4 months ago. If this employee next week would have been on the schedule for 45 hours, but except for this leave, then you treat it as 45 hours. So basically, for the purposes of how many hours is a week for that leave, it's looking forward, what would they normally have been scheduled for? When you talk about the rate of pay, as far as like how it's paid out, that's where you have to go back to 6 months and basically take the wages for the 6 months and divide it down until you get a daily or an hourly rate.
And that would be for both both laws. We would have to get that hourly rate for both the 2-week emergency paid sick leave and for the emergency FMLA.
Correct. And that's because it's under the federal rule. So in California, we don't normally go back 6 months like that, but because this is federally provided leave, they're generally under the FLSA and under different rules than we normally use.
Okay, not the answer I was looking for, but helpful. Thank you. Thank you. And this.
Oh, go ahead. One more. Was there any more, Karen?
No, thank you, Toni. This was really helpful. Thank you so much.
Fantastic. Now up is Miss Kate. Are you there, Miss Kate?
Yes, I'm here.
Okay, you had it.
Can you hear me?
Yeah, so which one of your burning questions? You have a couple of them here.
Well, actually, I'm going to shift gears a little bit. The extra $600 with the unemployment, is that going to be done on a sliding scale? So for instance, you know, when our employees file for unemployment, because we are a seasonal business, so sometimes, you know, they will get maybe only $200 a week. And we're concerned because we're an essential business, and I've already had employees say, well, once this comes through, it's better for me to go off on unemployment. You know, I'll only be making $100 less, and I don't have to come to work. And our problem is we've already offered, because we had to give off so many or lay off or furlough so many employees. Now we're getting down to a reduced amount, and I don't want to say, well, no, then you'll have to go, you know, we will say you were offered work, and them to say, well, you offered all these other people work. So I wanted to know, like, again, I guess more importantly, is it on a sliding scale, or is everybody just going to get this blanket $600 a week?
Right. So on that, it's a flat 600 across the board, and I believe, based on my review, it includes self-employed, independent contractors, part-time employees who may not even normally be eligible for unemployment benefits.
Wow.
And again, the reason is because it was being done in such a rush and they're trying to get benefits out. They didn't want to put the burden on the states to have to go back and try and figure out, like, what did this person make over the entire last year, and is that going to come out to more or less? So they went with this flat across the board $600, which there was a little bit of heartburn by a few people about. But again, as I said earlier, it's not really their choice. As far as, you know, hey, I want to just go on unemployment because I'll make more. It's if they quit, you know, they don't get to just quit and then go on unemployment. They're not eligible for unemployment if they quit. So technically, it's really the employer's choice, not theirs. But certainly, that doesn't mean an employee can't try and get creative if they want to find some reason to get you to let them go. But again, and it's only for 16 weeks, the increased amount too. Whereas the normal unemployment has been extended up to 39 weeks total, but it's only 16 weeks at the increased benefits, which probably at this rate won't kick in until maybe around April 10th, I would say.
Yeah.
It's usually about 10 to 15 days, I think, before it'll kick in.
Okay. All right. Well, that I think is very helpful. And then the other question about the sort of shenanigans, to borrow the term from the previous person, you know, I already had an employee that said, oh, well, I'll just go off on this paid childcare thing, even though he has, his wife is a stay-at-home, and really there's no need. I mean, they have one child. And so I just don't want to get us in trouble and say, well, no, he took off the paid leave. And so I wanted to know, can we have them sign something that says, no, I attest that I'm taking this time off to care for my child who is out of school?
Yeah. I mean, I'd have them sign something anyway, or provide some sort of documentation where they say what the reason is. Again, because you then have to certify to the taxing entity that, you know, for the payroll tax credit, that there was a proper reason. So I would certainly want the backup from that employee as far as them affirming why they're out. So yeah, I mean, I would definitely do that regardless of if you think it's a legitimate situation. I'd still have them do that.
And we can have them sign that. I mean, is it going too far to have them sign it under penalty of perjury?
I don't believe so, because first of all, the whole program requires the employer to then certify that it was appropriate. So there shouldn't be any reason they can't sign under penalty of perjury. Normally, anytime I have an employee sign any sort of acknowledgement, I like to do it under penalty of perjury because that makes it admissible in court. And now if they change their story, they've contradicted their a sworn statement. So I don't see any problem of saying, it's under penalty of perjury under the laws of the state of California, or, of the United States of America. I mean, I would do it under penalty of perjury. I don't see any problem with that at all.
Okay, great. That really is very helpful. Thank you so much.
Awesome. Thanks, Kate. Next, I'm going to go to Miss Tammy. She has asked a few questions here as well. Miss Tammy, are you there? Miss Tammy, I unmuted you. Let's see here. If you can't talk, I will talk for you. How about that? Here is Miss Tammy's question. She says, I thought I saw in the federal rule that there was a limit on the unemployment, that the maximum cannot exceed the amount they made before the layoff. Is that true?
No. There's two components. There's the state component, which is unchanged as far as how it's calculated. And in California, that maxes out at $450, and that's the sliding scale that was referenced earlier based upon the income. The federal is just a flat 600. So if they, and this is one of the things that was being debated and why it got held up a little bit. If they made $800 a week, and under California, they get $250 a week, plus they get the 600, and that puts them at $850 a week. No, there's no, it won't matter. It's basically they get their California amount, and then they get the 600 added on that the federal government's guaranteeing to credit the states. So yeah, the extra 600 is just a flat amount regardless of what state you're in or how much you make. Although the state amount, of course, still has its caps. So in California, the max anyone could get would be at 1,050 because of the 450 cap in California plus the 600.
Perfect. Thank you. Tatiana, you had a question. Did you want to ask Jim? Uh-oh. Maybe I scared them. Let's see here. Tatiana asked, an employee who earns commission but continue to get paid their regular hourly wage but not commission, can they apply for partial unemployment?
That's interesting. These type of questions get a little tricky because I don't normally represent individuals applying for unemployment. So as far as how it's calculated, I don't generally get into that too much. I know there's provisions for a reduction of hours. If somebody gets a significant wage drop from what they normally get, they may be able to apply for the difference. I would say what you recommended earlier, which is if that's the case, I would try and apply for the partial wage difference and let the EDD sort it out. They'll contact them if they need more questions regarding eligibility. Right now, you can't get anyone on the phone over there. They're swamped. So I would just submit the application online for like a partial wage benefits or partial decrease in wages, and then let them, contact you and try and sort it out for you if I was an employee.
Perfect. We have a question from Maria. Maria is from a very, very, very large client of ours. They have far north of 500 employees. So do they need to even put this up within the workplace, the employee rights notice form from the DOL?
No, if you're over 500 employees, you're 500 or more employees, those the provisions of that federal act regarding the paid leave do not apply to you, so you don't need to post that. It only provides information and notice of rights as to the covered employers, and they would not be a covered employer.
Perfect. Okay. I do have a few from Natalia, but she says she only wants to be in listen-only mode. Here's what it is. The new Emergency FMLA first 2 weeks paid out employee accrual, the remaining 10 weeks paid by employer. Is that the new federal requirement that employers will get reimbursed?
Correct. So the way it's set up is the first 2 weeks is unpaid, and they can use any other existing sick leave or PTO they have. If they don't have any already on the books, they would have that 10 days or 80 hours under the paid sick leave. So the thought would be if you don't have any that you could use, you're getting these 10 days up to 80 hours paid sick leave, use that concurrently for the first 2 weeks, and then from weeks 3 through 12, they would be under the paid leave. Both are the paid family leave part of it. Both of those, the paid family leave and the paid sick leave, there's an employer, should be a dollar for dollar employer payroll tax credit for either of those payments, or for both of those type of payments.
Got it. Okay. Jim, I wanted to thank you so much for, I know this was last minute for you. I think I added in some information an hour before we actually were presenting, but thank you so much for being on this call today. For all of my clients that are on the call today, thank you so much for being on the call as well. Like I said, we'll be reaching out to each and every one of you. What I'd like to do is either set up one-on-one or set up a group of 2 or 3 of you so we can walk through best practices. Also too, I've got my orders to take this and kind of make it into a form. I'll put the legalese in there for you, Kate, if you want to make it official. But I do think it's just like taking any sort of leave. Well, what is the reason? And if you need documentation into regards to why, at least you've had them check it off. Kind of like an I-9. Are you an American citizen? You tell me. There's 8 different categories. There's 6 here. So I think that would be really beneficial. I'll be working on that. Please call us if you have any questions. Please let us know how we can help you. Please stay safe, stay well.